So welcome to my legal English course. This is our first actual class. We're going to be teaching content. This is an overview of a little bit of English legal history and a little bit of what constitutes the idea of common law, which is very different to us as people who went to law school in a civil law country. And that will be analyzed in further depth in our second class, which will be specifically common law versus civil law. All right. So I did the course presentation in the last video, but just to go over it again, there's a little bit of a mandatory reading, and the idea in the course is to learn English legal terminology, and so that you'll be well equipped to deal with foreign clients, and that you'll be well equipped to read text in English, specifically legal text. It is not an alternative to attending law school in an English-speaking country. So the method, as I said before, is going to be our 18 lessons. And there will be a lot of reading. There will be 10 mandatory case law readings. I've selected it. I selected the most important ones for us to understand the legal terminology specifically. If you're a contract law lawyer, if you're a criminal law, defense lawyer, there are a lot of other cases in our Google Drive. I've put probably dozens of cases there, which will help you gain a better understanding of your particular expertise in law. It is, again, not an alternative to actually attending law school in an English-speaking country, but it's enough for us to understand the influence and to understand foreign law when we have to apply it to our reality. So English law is very interesting, and it contrasts with continental European law, specifically because of the Magna Carta, which I'll go into depth later when we study English constitutional history, and also the Norman Conquest and the diminished influence of Roman law if compared to the rest of Europe, right? So in 1066, in the Battle of Hastings, the Normans took over England and instituted French as the mandatory language, which is why a lot of early English law will be full of French terms. So you have the Champ d'Étoile during the reign of Henry VIII. You have autrefois acquis, autrefois convie, which stands for double jeopardy in old legal English. We'll go over that when we study criminal procedure and civil procedure. But also because in England was the first to really develop the idea of a parliamentary supremacy, and that was very different even in the early medieval period from every other European country, as we'll see in the English constitutional law class. Right, so as I said, the Norman Conquest was in 1066. Before that, you had the period of Dane law, which was when the Vikings took over England, and you also had the Anglo-Saxon invasion, and you had the Roman period until the 5th century, and before that you had Celtic influence. So it's a lot of things that are very difficult to understand if you're not a historian. So what matters to us really is the invasion by the Normans and the Magna Carta, which happened a few centuries after that. And William the Conqueror, we'll also analyze that, also played a role in creating this approximation between English law and European law. So there's a lot of historical context that you have to understand in order to gain a full understanding of legal English. All right. And a custom, this is important because time immemorial is something that people still say in English-speaking countries in legal settings. It's basically a standard of time, right? So it's so long that you don't remember when it started. And that's something that used to be a legal requirement for a custom to be enforced by law. That's what established the idea of common law, was the idea of custom. And that's why we say common law. And that's going to play a huge role even when we study the American Constitution, as we'll see in class number 3, which is American constitutional law. Class number 4, which is American constitutional law. Right. So common law, as I said, was the unwritten law, the law of custom. The non scripta would mean not written. This law was applied and enforced by courts in the English system, many times by judges who weren't lawyers, because the idea of studying law and being a lawyer is something that didn't exist in the medieval period, which meant that common law was something that was very accessible to a normal person. It wasn't something that was complicated or out of reach. That's why it's called common law. The common law is specifically intended to safekeep customary law and to protect the way of life and the habits which wound up playing a role in the development of capitalism in England beginning in the 16th century. Equity, on the other hand, this is different. when common law was insufficient, so when a custom didn't exist, when some sort of injustice had occurred, the king could use his prerogative and the royal courts could use their prerogative to apply equity. Equity just means fairness. So I'll judge according to what I think is fair. And you see this when we read case law by the American Supreme Court, that there isn't a lot of sophisticated philosophical arguments the same way you'd see in the German court or even here in a Brazilian court. It's more of an idea of like what would the common person think is fair? What would the normal person think is equitable? So when there was no common law custom or no common law norm for a certain thing, you could use a remedy, and the remedy in an equity court would be decided in accordance with this idea of fairness, and it would then become a binding precedent. So this is where stare decisis comes in. When you have a binding precedent, you have something that has to be obeyed. So equity helped create the law when common law was insufficient. It assisted the law, but it didn't create the law. It came in basically to fill in gaps. And you're going to see that when we study the 7th Amendment of the American Constitution and when we deal with civil procedure in the United States. So common law, commercial and municipal courts, like I said, it was very important for the development of capitalism that certain customs, in particular in the area of commerce, be observed, even if they were not written, right? This is a period where most people were not literate. So having the ability to have customs enforced by a court in a common law court was very useful for a merchant. Equity, on the other hand, was a more drastic measure. For instance, when we think of writs, such as the writ of habeas corpus, this happens when someone is trying to challenge their imprisonment. So you can't really deal in accordance with the sense of common law, because the idea here being that this is something that the system, a failure in the system that had to be remedied by a remedy. So that's why you say remedies precede rights. So because you step in with a remedy in equity to address something that the common law did not address correctly. Here we have a few writs in medieval England. If you study English law, some of this is still applicable. Most of it is not. This is where the idea of writ comes from, right? Because writ just means this command, this written command. When we speak of writ of habeas corpus or the writ of mandamus, those are remedies in American law, also in English law. And those are remedies that you can apply in a higher court. And originally in English courts, there were a multitude of writs, such as the writ of error, that's an example. But most of these writs don't exist anymore, as the system became more in line with international capitalism and globalization. But a lot of this is a very good historical example of how the procedural remedies sometimes were more important than the discussion about the philosophy of law or what was right or wrong according to some universal idea of ethics and morality. So here we have a case from the American Supreme Court. I have two cases actually: Garant Financiera versus Nordborg and Skolkin versus New York. Both of them are about the application of the 7th Amendment of the American Constitution, which deals with the use of jury trials in civil cases, which to us is very strange. But essentially what the American Constitution says is that when you have a case of common law in a federal court, you have to use a jury to determine the verdict. If you have something that isn't a common law case but is an equity case, then you can have the judge decide by himself. But if it's a common law case, you have to use a jury, right? So when you deal with this idea of natural law, when you deal with the idea of what's right and what's wrong, such as in the consumer case, you can use the common law jury trial in America and in the UK as well. So that's something that is very different from our legal reality here in Brazil, in continental Europe, all right? So this is a very good quote from the United States Supreme Court, which shows how they perceive the law differently from us, right? So the process of constitutional adjudication just means to decide, right? So it does not thrive on conjuring up horrible possibilities that never happen in the real world and devising doctrines sufficiently comprehensive and detailed to cover the remotest contingency. This is something that is sharp contrast from what we think. We have a lot of legal theories, and we try to make them as broad and as wide in scope as possible, whereas American law is more about solving conflicts, going on a case-by-case basis, and common law in general. So this is why you have to stick to the case and the controversy, and you find a remedy that is good for that specific case. That's why if you look at something like the death penalty in the United States, there are a multitude. One specific case is going to outlaw the death penalty for minors. Another one is going to outlaw people being burned alive as a form of execution. So they're not going to make one big decision which can be applied to any and all cases. They're going to go on a case-by-case basis, which is why it's so important to observe case law and to observe precedent. These are two sentences in Latin, back when Latin was still influential in English law, which is in the Middle Ages. Today, if you read an American a decision by the American Supreme Court, you're going to be hard-pressed to find any Latin. They usually refrain from using Latin, but in English law, it's still relatively common. But old cases mostly use Latin. Under Roman law, you have the idea of salus populi suprema lex, which means the people's welfare is the supreme law. Whereas in Anglo-American law, and you can read this in case law from the 16th and the 17th century from the United Kingdom, which was back then was just England, is sicuteri tu ut alienum non laedas. So use your own property without injuring others. So it's the idea of the individual versus the collective, which we see reflected both in their culture and in their legal system, because really a legal system is only a reflection of a given culture, right? That's why compared law is just a branch from legal anthropology, which is something we'll discuss in our very last class. Right. So in the modern period, there's been this convergence from especially in England, with legal systems that exist in other countries. You know, they created a Supreme Court in 2009, which does not have the power to conduct judicial review. They abolished the role of the House of Lords, which is the upper chamber of the British Parliament in the legal system. It used to be the final say in litigation used to go to the House of Lords. Now it goes to the UK Supreme Court. And the appellate courts in these appellate courts, people are still called Lords of Justice, but they're not members of the British House of Lords and they're not peerage. But there's been a convergence to make the English judicial system a bit more like the legal system in other countries, because it is still a very strange legal system, I think, to us, much more so than the legal system in the United States, especially because we based a lot of our legal system off theirs, especially the idea of a Supreme Court and the idea of judicial review, which, like I said, does not exist in the UK. Before, there was this idea of writ, and now it's a bit more easy to comprehend. So if you really want to look at where the differences come from, you have to read older case law, right? More recent case law is going to sound and feel more familiar to us. Right. Also, in terms of society, in the UK as well, there's been a convergence with a welfare state. The idea here being, in 1946, you have Clement Attlee being elected prime minister, and he created a lot of things that in the United States would not be well received, right? So the idea of the NHS, the idea of public housing. So these are things that also make the United Kingdom a little bit more similar to us today than the United States in terms of the legal and constitutional system, but which are relatively new additions.